Welcome, my name is Ted Flanagan from Gosschalks. We're the Employment Law Department at Gosschalks, and we'll be speaking in due course. And Sarah from AP Robinson is going to speak today as well about national minimum wage and employers' national insurance contributions. Not that you need telling about that. We do these seminars twice a year. The point is to bring you up to date in terms of employment law and what's changing. We've been doing them for we've forgotten, but we think about 15, 16 years. And there's probably never been as much turmoil as there is at the moment. So we look at new legislation. There's one aspect of that this time. We look at legislation that's going to come in, Labour's changes in effect. And we look at cases. Sometimes cases change the law. A case can put the flesh on the bones from a piece of legislation. Years ago, the Working Time Regulations, 1988, often we get cases that tell you what the hell they were supposed to mean all those years ago. Sometimes a case doesn't change the law, but what it does do is flag up an interesting point, tell you about that. And sometimes we just do cases because they're quite funny, which possibly isn't the point of an employment law update, but we do appreciate can be a little dry. I hesitate to say we aim to entertain, but we do our best. We also do practice points. Practice points are where we deal with all sorts of employers across all industries of all sizes, but sometimes we'll notice that an issue is cropping up. So we do that as a practice point. This time it's the national minimum wage on one aspect, because that's a big issue. In a way it never was for clients, it is now. And redundancy processes, we're going to look at a very brief guide to how you make people redundant. So it's 2 o'clock, it's 3 o'clock, wrong year, wrong hour. Let's look at what is coming up in the future. So I'm going to talk inevitably about the Employment Rights Bill. We did our last employment law update in September last year, and at that point we were waiting for the new Employment Rights Bill. Labour had come to power in July, and they'd promised within 100 days a bill to change employment law in a way that it had never been changed. And that's pretty much what we got. Exactly 100 days later, on November the 10th, 12th, the Employment Rights Bill landed with a resounding thud. In ways, strangely, this might sound an odd thing to say given that it was such a trauma at the time, it was a bit of an anticlimax. Yes, there was 150 pages of it, but a lot of it doesn't apply to the average employer, the average business. You're not that interested in collective bargaining with large trade unions. And almost all of it had been sort of told to us in advance, because that's the way politics works these days. Nobody ever actually announces anything in the House of Commons. They trail it or give favourable interviews to journalists who are going to put a supportive spin on it. And as the election approached and Labour realised they were going to win, they needed to do less to please the unions, more to please industry. So they started to not only tell you about what they were going to do, but water it down to a great extent. So October the 12th, it landed. Lots and lots of changes. I mean, to say it was an anticlimax, I say that because a lot of clients feared it was going to come into immediate effect, particularly the unfair dismissal qualifying period, which I'll come on to. Some people even worried that it was going to come in retrospectively, but it didn't. All of the timescales are measured in years, pretty much, and everything is going to be subject to implementation periods, passages through the House of Lords, codes of practice, all of that sort of thing. So here we are now, as of today. It's been through the House of Commons 3 times. It's gone to the House of Lords the other week. Now weighs 310 pages, and it's expected to receive royal assent in the summer. So where are we now, 5 months on from October, with what it's going to change? Well, undoubtedly the big one was the unfair dismissal qualifying period. This is what worried clients most. I kid you not that some clients asked us about sacking people prior to the Employment Rights Bill, just in case it came in with immediate effect. One client promised me faithfully he had all the P45s ready. I just said the word. It's going to happen in autumn 2026, so that's one reassurance. But what's going to change? Well, we've had unfair dismissal protection in UK employment law since 1976. And there's always been a qualifying period. It's been 6 months, it's been 1 year, it's been 2 years. The current 2-year period we all know and love has been with us since 2012. As I say in the handout, as we always say, it's not quite 2 years, remember. It's 2 years minus 1 week because of the way you calculate it. So what changes after 2 years? Well, the unfair dismissal regime comes into play. You've got to be able to rely upon potentially 5 fair reasons in UK employment law. and you've got to be able to follow a fair procedure. And we've known for at least 3 years that Labour were going to make it a day one right, and that's what they've done. So unfair dismissal is a day one right when this comes into effect at the end of next year. But we're going to have some sort of probationary period type system called an initial period of employment. So what we think is going to happen is you'll start people, they'll have unfair dismissal day one rights, but for the first either 6 or 9 months, we think probably 6 with an extension of 3 months to make it 9 in certain situations, you're going to have what is going to be described by most people as unfair dismissal light. And we say that because we don't precisely know at this point what it's going to be like. But if you think about dismissing somebody with more than 2 years service, you need a fair reason, you need a letter, you need a meeting, you need a right of appeal, you need all of that. What we think is going to happen once this comes in is for the first 6 months or 9 months, you're going to need some of that. More details to come in due course. What we do know, we think, is that redundancies aren't going to be covered by that. It's going to be capability and conduct. So redundancy unfair dismissal probably is going to be a day one right, but things have gone badly wrong if you're making redundant the person you recruited last week. So we shall wait and see. Is there anything good can be said about this? Because a lot of people are very depressed about it. I mean, let's be honest, we have a system whereby you can bring an unfair dismissal claim online for free. It used to cost you a stamp in the good old days to post it off to Leeds. You do it for free these days, and employers cannot recover their costs if they defeat that claim. So millions of people now going to be within that regime. What good can be said about it? Well, 2 points we think at best. First is 2 years was probably too long a period anyway. If you've got someone who's coasting along for 2 years because you're thinking, I've still got plenty of time to get rid of them, that's not ideal, and they're wasting 2 years of your time, basically. So it's going to put a new, renewed focus on effective recruitment in advance of making appointments and more rigorous performance management from day one. That can be a good thing. Lots of people saying, what can we do about this? The answer is wait, but you may as well do that now, have more rigorous performance management and effective recruitment. Another upside possibly is as follows. If you've got an unfair dismissal claim, that's a pain in the posterior and you're not going to get your costs back and you have to go through the process, perhaps takes 9 months in the Leeds region, but you can win it. If they haven't got 2 years currently, we all know they cobble together some sort of half-baked discrimination claim or whistleblowing claim, and they're far more complicated to defeat with preliminary hearings and more paperwork. So there'll be less of those, hopefully. So that's unfair dismissal. Employment Tribunal claim limits are currently 3 months minus 1 day for every claim you can think of almost. That's 3 months from the dismissal or 3 months from the last discriminatory act complained of. This is going to be 6 months. Good in some ways because there are situations where people issue ET proceedings because they have to, because they're running out of time, even though an appeal is ongoing or a grievance is ongoing. But that might happen less. But more claims might be brought potentially because people who've missed 3 months might not miss 6 months. And you're going to be waiting longer to know whether you're out of the woods or not. So if an employee leaves you and bids you a cheery farewell and says, I'll see you in bloody tribunal, at the moment, it could be realistically 5 or 6 months before you know whether that's happening, probably, possibly longer, 6 or 7 maybe. That's going to be the best part of a year before you know. Another change from the Employment Rights Bill, the Fair Work Agency. Now, this was mentioned in the bill, but not a lot. I mean, in terms of the changes it suggested it was going to involve, it didn't even make the top 10, if we're honest. But there's more of it in the amended bill recently. The Fair Agency is going to be able to bring claims on behalf of workers and enforce their rights, even if they don't want to do it. Going to have the agency's costs potentially recoverable if a claim is successful, have right to pursue employers' unpaid holiday pay and sick pay with financial penalties on top if successful. So a bit like the national minimum wage regime, where if you've underpaid, they charge you twice as much on top and keep the money. So the Fair Work Agency has suddenly come large into view and is going to be very significant. We don't know when it's going to happen, but there is going to be a body that pursues employers on behalf of employees generally. Sexual harassment, we talked about this in September. Sexual harassment of third parties is going to become, by third parties is going to become unlawful. So you're doing your level best at the moment to stop your employees sexually harassing each other. You've now got to worry about customers, other people's employees, delivery drivers, all of that sort of thing. Flexible working has changed slightly. You can still turn flexible working requests down on those 8 fairly vague statutory grounds, which I list on page 7. just in the future you have to explain it better. Lots of other changes coming, simplification of the system whereby people are either self-employed or employed, doing away with worker status. Lots and lots of changes to come, and we'll be talking to you again about those in September. One change that's not going to happen, let's finish on a bright note. The right to disconnect, which they have in lots of countries, where you're not allowed to be bothered by emails or calls out of hours, that's not going to happen now. The government have decided to pull the plug on it, unintended. Now, new legislation over to Ryan.
As Ted has said, the only new piece of legislation this time around, which we've identified has been from 2025, hopefully, the neonatal care leave and miscellaneous amendment regulations, which aren't effective yet, but will be on the 6th of April 2025. They will give a right to 12 weeks leave and pay when people's children require neonatal care. The idea is it's well-natured, is to stop them losing time off maternity leave, paternity leave, or shared parental leave. And broadly speaking, will benefit around 60,000 new parents. When this comes in, it will be a day one right, so an employee can bring this to you on the first day of employment and request neonatal care leave. There's nothing you can do to stop them taking it. And if they're in one of the 4 categories, which is listed there on page 8. What I will say is I'm going to breeze through this a little bit, because I've only got 3 minutes to go through this, keeping with our timing. So I'm going to allow you to read a little bit of this for yourself. For neonatal care to apply, it must be within the first 28 days of birth and continue for at least 7 continuous days. Neonatal care is any medical care received in the hospital, any medical care received elsewhere following hospital discharge, and palliative or end-of-life care. Employees can get a maximum of 12 weeks leave, subject to however long the child is in one of those 3 categories, and the week begins on the day after the care started. In most cases, this leave will be taken at the end of the family leave, whether that's maternity, paternity, or whatever, because with it being in the first 28 days of birth, there's a good chance that the parent will already be off on one of those types of leave, and the idea is it can just be tagged on to the end. But there is recognition that, of course, in emergency sort of situations, i.e. when paternity leave has ended, there might be a need for some sort of flexibility. And accordingly, the legislation does allow for any notice period to be waived, so that this can be taken immediately, subject to agreement between employer and employee. Rate of pay and week of service requirements are the same as maternity and shared parental leave, which is 26 weeks of service and earnings of at least £123 a week. And the other main point of note is that if someone is on neonatal care leave for more than 6 continuous weeks, then they will be protected from redundancy until the child turns 18 months old, and will have the right to be offered a suitable alternative vacancy. And we've just added some sort of considerations there, what you might wish to think about moving forward. The most obvious of which is the policy for your staff handbook. It will apply irrespective of whether it's in your handbook, whether you have a policy on it or not, but you might want some clear provisions as to how you move forward. Everything that on sex discrimination.
Right. Sexual discrimination, sexual harassment. I've done quite a bit of training on this for clients, and I've gone through a lot of cases with them where sexual harassment has been upheld and what it looks like, how it's described, the tests involved. What I'm going to go through with you are 2 cases where it's not upheld, just to show you a bit of a balanced view here. So you're aware, the type of behaviour that can amount to sexual harassment is listed by the Equalities and Human Rights Commission. And I'll just go through that list for you. It's on page 12. This is unwelcome touching, hugging, massaging or kissing, propositions and sexual advances, sexual comments or jokes, displaying sexually graphic pictures, posters or photos, suggestive looks, staring or leering, making promises in return for sexual favours, sexual gestures, questioning about a colleague's private life or sex life or discussing your own private life or sex life, spreading sexual rumours about a person, sending sexually explicit emails or text messages. So it's quite a broad scope of behaviour. Now, in this case, this is Miss Chen versus Cut Your Wolf Loose Limited. I think it's a whiskey company. It was agreed by everyone that Miss Chen and her manager would walk her home, and it was agreed by both that occasionally they would hug when you'd walked her home. That was something they both consented to. But when Miss Chen raised her claims, and she raised a variety of claims in respect of her employment, she said, well, actually, on 2 of those occasions when you hugged me, you kissed me on the neck, and that wasn't wanted behaviour on my part, so that's sexual harassment. And the manager said to the tribunal, no, that's not what happened. We did hug, and I did kiss her, but it was in an air kiss kind of way, so it was a hug, and I just kissed the air. Now, Miss Chen already as a witness hadn't been particularly credible in front of the judge. There's a lot of things that had been said that were inconsistent and just not supported by the evidence. So the judge said, I believe what the manager is saying in respect of this, and that it was just an air kiss. But what the judge also said was, I do not consider that an air kiss is unwanted conduct of a sexual nature, or alternatively, if it is sexual, it's not at a level, even regards her perception, where it's reasonable for it to have that prescribed effect on her, i.e. the behaviour was not enough to violate her dignity or create a hostile, intimidating or degrading environment. What this means for you is that I don't think in every context, and it's possible if the hugs hadn't been wanted and had been forced on her in some way, and with the air kiss there, that could have been sexual harassment. And I do think it's quite important to be thinking, in a work context, the least physical contact, the better between people, just so we don't end up in this kind of situation and a big argument about whether something was wanted or not, especially when somebody's the manager, somebody's more senior in that situation. But a good point in this case was the judge seeing that really she was trying to elevate something that wasn't a big deal to her or anyone at the time, but she was trying to use it to support other claims that she was making and make the behaviour seem worse than it was, and the judge wasn't having any of that. It wasn't the case that the employee was always correct in these situations. It wasn't how the employee had set it out. The second case I'm going to talk about is Hennell Whittington versus Metcalfe and Sons Limited. Now you'll see I've written a couple of pages on this, and this is because the story is quite interesting, but I'm not going to go through it in detail. That's a bit of bedtime reading for people if they want it. But it's another case where sexual harassment was alleged but not upheld. So in summary, the respondent, the managing director of the respondent, he created a role for the claimant, a role which she really didn't turn up to do or barely performed. And the reason he did this is because he thought they were in a relationship, albeit a non-sexual relationship. It was she had a fiance. He thought she was going to leave the fiance for him. And it was this clandestine relationship that he was assured would become something real in the future. And the relationship was very much based around financial matters. Like, he would give her a lot of money, he would take her shopping, anything she wanted or desired, he would pay for, and he spent quite a lot of money on her and had created the job as part of this. The text message evidence between them was very much that he thought they were having a romance, and he would express that he was in love with her, and she wouldn't say that back, but she would say, you know, this is long term, we're going to be together in the future. It's just I'm delayed, you know, there's reasons to delay it. I've got this fiance I've got to deal with. I've got things I've got to deal with my daughter. There was a particular occasion where he did take her shopping and he tried to hold her hand and touch her bottom, and she told him to stop, and he did. But that's the only sort of physical situation she'd raised. And then about 15 months after meeting, about a year after she was doing this job with him, the respondent held a gala, and she didn't attend it with her fiance, nor did she attend it with the managing director. She had a new boyfriend at this point that she'd met at the gym a couple of months earlier, and she brought him to it. And the penny finally dropped for the managing director that really he wasn't in a relationship with her, despite the promises, despite the things that had been said. And he said to her, we can't work together. He created this PA role for her so they could be together. And he said, I don't think we can carry on with this. She asked for notice. He gave her 2 months, even though she was entitled to a week. And then she sued him for sexual harassment and discrimination from being sacked. And her argument in the tribunal was that they were never in a relationship, and he was trying to force or pursue this relationship. He tried to touch her on a couple of occasions. And this was sexual harassment. Now, the tribunal had 2 lever arch folders of evidence of the text messages between them both. And they said, no, you knowingly allowed him to believe you were in a relationship. It wasn't harassment. And even if some of what you're saying is unwanted, You did not have your dignity violated. I mean, really, this is the other way around, but it's the test that the judge is applying. It's not degrading, it's not hostile, and you've created the very environment that you're complaining about. And the reason you were doing what you were doing is you wanted the lifestyle that the money could pay for. What this means for you is this is quite an unusual situation, but it's another red flag about relationships at work that go sour or go wrong, and how that can be turned into a sexual harassment claim. It was extremely embarrassing for the managing director in this claim, because not only was he humiliated at the time, he's then had this publicised, it's been in the newspapers, it's a public tribunal judgment that can be read. I'm telling you all about it, although I've not mentioned who he is, but it's easy to find out. But it's very unusual for the respondent to be the victim in the situation, but in this case they were, and I think it's important to bring it up as a balanced view in sexual harassment law.
First time I've done this, honestly. I'm going to give a little bit of overview of pre-termination negotiations. Most people will be familiar with the concept of without prejudice conversations, protected conversations, which is basically to say that they are off the record and don't prejudice either party should a successful negotiation not happen. So basically it can't be relied on in any future tribunal claim, which is what Mr. Gallagher tried to do in the case of Gallagher and McKinnon's Auto and Tyres. He was dismissed in August 2022, and there was some sort of pre-termination negotiation going on to try and agree an exit package as to how he would leave the business. Ultimately, that didn't work, and he brought an unfair dismissal claim against his former employers. He tried to rely on what had happened in those negotiations as part of his evidence, so to remove the without prejudice bit and to totally prejudice his employer. He did that in three sort of distinct ways. He said that the meeting where the conversations had taken place had been under false pretenses. He thought it was a return to work meeting, but actually it's been used to offer a severance package. He'd been given only 48 hours to consider that package, which contravened the ACAS guidance of 10 days, and that his employer had exerted undue pressure by stating that if he didn't agree a contractual exit, then he would be made redundant. The Employment Tribunal saw nothing wrong with what had happened, but Mr. Gallagher took his claim to the Appeals Tribunal. The Appeals Tribunal found the same as the Employment Tribunal and dismissed his arguments for the reasons set out on page 17. Most importantly was that the ACAS guidance was guidance only and could be contravened. Mr. Gallagher had the opportunity to either accept the offer, counter it, or reject it, but he didn't do any of those things. And that the employer's comments regarding redundant were found to be genuine and not a threat of dismissal. What this means for you is that it's a good reminder that without prejudice conversations are generally inadmissible, and that there's not an easy deviation from that point as far as the tribunal is concerned. You've got to have good, strong evidence. And the other thing is that ACAS guidance on settlement agreements is clearly just guidance, and it can be fluctuated from without being improper.
Hi, so I'm going to talk to you about the case of Jones v. Vale, Curtains and Blinds. Now, this is a recent unfair dismissal case, and Miss Jones worked as an employee since 2021. In 2023, she was dealing with a customer who was making repeated complaints in an attempt to get a full refund. She decided to forward this complaint to her supervisor, stating, "Hi, Carl, can you chase this? He is a it doesn't matter if you can't." And instead, she accidentally pressed reply rather than forward and sending the email straight to the customer. So not long afterwards, they received a call from the customer's wife saying, "Is there any reason why you call my husband?" So technically, there may have been good reasons, but you're not supposed to let the customer know. So in the aftermath of this, the customer wanted 3 curtains off the back of Jones's mistake. She was absolutely mortified and apologised profusely and offered to pay £500 out of her own pocket as a gesture of goodwill. Jones's manager also apologised and said that she would be reprimanded, but the customer did not give up that easily. They threatened to publish the incident on social media and leave a bad review on Trustpilot, and it was at this point that the employer decided to sacrifice Jones. So the disciplinary process was very brief, and she was sacked shortly afterwards. The employer then wrote to the customer saying, don't worry, we've got rid. After that disgraceful email, she's gone. The Employment Tribunal found that dismissal was unfair. But why was that? Because on the face of it, calling a customer gross misconduct. But the test the tribunals apply is quite wide, and it is in favour of the employers. In these circumstances, the decision to dismiss must fall into a range of reasonable circumstances. So what actually led the tribunal judge to this conclusion? So the first thing was the judge found that the employer did not consider the event to be gross misconduct at the time because they only issued a warning. It was the subsequent threats by the customer to go on social media that led to the dismissal. And secondly, the disciplinary process itself did not amount to a fair procedure. So Mrs. Smith, I think that was her manager, acted as the investigator, disciplinary officer and appeal decision maker. Miss Jones was not given adequate time to prepare, and it was not explained to her in advance the basis upon which she might be dismissed. The process itself was declared a sham, and the judge decided that the decision was a foregone conclusion based entirely on the threats made by the customer. There was a 10% reduction on a contributory fault basis to reflect Jones's actions in the first place, but in essence, she won a claim. So what does this mean for you? So the case ultimately emphasises the importance of procedure. It's probably fair to presume that if the employers had genuinely thought Jones's actions amounted to gross misconduct and then followed a fair procedure in law, she would have been dismissed without any issues. But the employer's actions made it clear that there was a fear of repercussions on social media that led to a dismissal. So the defective and hasty procedure that followed was further evidence of that. So of course, what we can all learn from this process is that you should check, and check again before sending that email, especially if you're calling someone. Thank you.
So that's why this seminar is 18 rated. I mentioned that we do practice points where something's cropping up for clients. As I mentioned earlier, a lot of our clients, because of perhaps national minimum wage, employers' national insurance contributions, the economy generally, are talking to us about redundancies. So we thought it'd be an idea to say a bit about redundancies. Redundancy situation in law arises in three ways. The employers stopping altogether doing what they're doing, they're completely shutting down. That's the first definition. Second is that they're stopping that activity in a particular place. But the third, more common definition is that their need for employees to carry out work of a particular kind in the place where the employee works has ceased or diminished or expected to cease or diminish. Basically, the business is moving forward, but identified it can do so with less staff. And that's the scenario that we deal with most of the time. The good news is that if you come to that conclusion, the law doesn't interfere with your decision making. It's your business to run as well or as badly as you want as far as the law is concerned, and they will not, as they say, pierce the corporate veil. Another important point to make is that you don't have to be in a crisis or a loss-making situation to make redundancies. It's up to you. If you decide that you can live without certain roles in the structure, that's your decision. You could be making absolutely fantastic profits and decide you can just squeeze a bit more out of them and make a few redundant and have even more money and less overhead. That's up to you. The law doesn't interfere with that sort of decision making at all. The important thing is to follow a fair procedure. Now, it's important to remember that redundancy is a dismissal in law. That's a mistake people often make. They talk about laying people off, which is a different concept. Redundancy is a dismissal, so you have to follow the rules on unfair dismissal, which, as we know, means 2 years is an important landmark. We also know that it won't be soon. I mentioned earlier redundancies aren't going to count. But because it's a dismissal, you have to follow the law on unfair dismissal. But redundancy is one of the potentially 5 fair reasons to dismiss in UK employment law, so that's a good start. The law does say you can make people redundant. Potentially fair reason. How do you turn a potentially fair reason into a legally sound fair dismissal? As always, as we're always saying, employment law is hung up on procedure and process. The key to a fair redundancy procedure is planning. Start by looking at your current structure, either for the whole business or the part that you're going to make changes to, and jot it down. Plan out what you want to do for the future, before and after family trees of your organisation. What roles can you live without? That's the start of your sort of planning of it. When you're doing that, focus on job titles and roles. So if you've got 3 lathe operators and you can do with 2 lathe operators, it's actually before and after. don't come to us with a note saying we need to make Jeff redundant because Jeff is the lathe operator you think you're going to make redundant. You know, because he's going to get it in the end. But at this point, the focus is on roles and job titles. And in theory, there's nothing personal about it. And redundancy is not a criticism of the person in the role. So focus on job titles and roles. And remember that from the start, what you're looking at is a proposal. You're not actually going to make a decision on redundancies until you've been through the consultation process. And that means that you've met with all the potentially affected staff, you've discussed the situation with them. When we deal with redundancies, we do the first letter, which front loads everything, says to the staff, this is why we think we're going to make redundancies. This is the potential effect of it. You might be affected. This is the process we're going to follow. And follow a fair process. That involves, as I say, consultation letters. As I always say to clients, I may have said to some of you at times, that law books are full of situations where tribunals have said, not enough consultation. I've never come across a judge saying there's been too much consultation here. So what you take from that is have that extra meeting, send that extra letter. Point of the consultation process is you explain the basis of the potential redundancies to the affected individuals, and that includes any matrix you're going to rely upon, because if you're taking 1 out of 3 lathe operators, it's Jeff, I'll let you in on that secret, out, then you have to have a matrix that you mark Jeff and whoever else against. You consult on that as well, give them the opportunity to comment before any decision is taken. If you front load it and are open and honest about it, 2 things happen. Firstly, you're less likely to be criticised by a tribunal. And secondly, the staff themselves are more likely to understand. People do understand that you need to cut costs in businesses. And if you're open with them, they generally act quite well. So redundancies, a fair dismissal in law, one of the 5 potentially fair reasons to dismiss, as I say. Law doesn't interfere with your decision making. And the key ingredients, 3 Ps, planning, procedure, and as always, patience. Take your time, otherwise you might get caught out. So that's redundancies. And now over to...
We've spoken many times at these seminars about previous cases where gender-critical beliefs are protected beliefs for the purposes of employment law. What we haven't done is discuss that in a gender fluid, DOD context, which is what we're going to do now. And now everybody's listening, aren't they? So Miss Pitt, who brought this claim, was a lesbian who was part of her employer's LGBTQIA plus group. One of her colleagues, don't know how the conversation came up, explained that his dog was gender fluid and put it in a dress so they could have a debate about gender. Miss Pitt was firmly of the view that gender fluidity isn't really a thing, and was very critical of gender fluidity, particularly in the context of women's sports. Some of the attendees took the view that Miss Pitt had been quite aggressive in what she'd said, and found her input generally quite offensive. They reported what she'd said, but particularly what they reported was about her views and not how she'd said them. And that's an important distinction, which I'll come on to in a minute. Miss Pitt denied being aggressive. She was asked whether the meeting was the appropriate place to discuss what her views were on gender fluidity, and she questioned what the group actually was for if it wasn't for that. So what eventually happened was the respondent, the employer, prepared a report stating that Miss Pitt had expressed non-inclusive and transphobic views, which caused offence and had a detrimental effect on her colleagues' mental health. The employer instructed Miss Pitt to make sure that her personal views didn't manifest themselves inappropriately in workplace meetings, and she was barred from attending the LGBTQIA plus group and was not allowed to contact the members. She was told this was all informal action and had been taken under the disciplinary procedure of her employer. Miss Pitt raised a grievance and later proceedings of harassment on the grounds of her sexual orientation and protected beliefs. The respondent tried to defend those proceedings, saying that the whole course of action had been taken because of her aggressive manner, but could produce no evidence to substantiate that. And so the conclusion was that it had been a successful harassment claim, and she was awarded £56,000 in damages. As I said, we've had lots of similar cases in this sort of context. Employers can't take action against employees for protected beliefs, even if there are people who don't agree with them, have totally contrasting views. An action can only be taken when the manifestation of that belief is inappropriate, if, for example, it's been put forward aggressively.
Last of the cases for today. We do cases if they make the news because employment laws are very badly reported. usually. And so if you've read about something in the press, it's often helpful for us to talk about the underlying legal themes that actually apply. This is Walker v Robson's Rickmansworth Limited. If they make a film of this, it'll be called Estate Agents at War. It's a constructive dismissal claim. Constructive dismissal, as you know, is a type of unfair dismissal, but rather than the employer dismissing the employee has resigned, but it's a dismissal because the employer has behaved in such a way that they have fundamentally breached the contract by destroying the trust and confidence of the employee, usually. So the respondents were estate agents with 2 branches in Hertfordshire. Mr. Walker had worked for them for many years as a manager in the main office in Rickmansworth. They move him to the sub office in Chorley Wood. Stay with me on this one. And they do so with a phone call out of the blue. And they replace him in his managerial role in Rickmansworth because someone else has come along who was too good a candidate to miss out on. So sorry, mate, you're off to Chorley Wood. They change his commission scheme, but they don't bother to talk to him about it. They wait until he's not at his desk in Chorley Wood and leave a letter on his seat. 2023, they plan to bring him back to Rickmansworth because the new guy's not worked out, but only as a joint manager. They tell him that. They don't bother to tell him that it's on the basis that he gets the high-end, large value work, because that would be a positive. They only sort of tell him the bad stuff in passing, in effect, and this continues. And then we come to the reason why this case was in the papers, because it was widely reported as being sacked over a desk. Now, in the main office, there's a particular desk that the manager sits in, and it brings with it all the gravitas that you have for an estate agent's manager's desk in Rickmansworth in Hertfordshire. When he's going back as joint manager, he's told that he's going to sit in the middle desk, and this is a considerable slight to his professional integrity. The director who's dealing with it doesn't know any of this because he hasn't bothered to speak to anybody about it. They never speak to him. They never speak to anybody else. But he decides to go across and speak to him in Chorley Wood. But on the way there, he gets himself on a war footing because he's somehow convinced himself that the guy is going to resign and go to a competitor. He takes advice on the way there from an advisor who gets him all riled up and says, this is how you're going to have to deal with him when he resigns and says he's going to a competitor. So he goes into the office in Chorley Wood. Both of them are in an emotional state to start with, and it goes downhill from there, frankly. And then, raising his voice, the manager says to him that I cannot believe a fucking 53-year-old man is making a fuss about a desk. That's what made the papers, inevitably. He threatened the claimant with disciplinary action if he did not move back to Rickmansworth and sit where he was told. Claimant threatened to resign, and he replied, go on then. Claimant did. Tribunal ultimately concluded he had been constructively dismissed. What does this mean for you? It's unlikely that you run estate agents in Hertfordshire. I appreciate that. But really, when you look into this case, it's about difficult conversations. And reading back through it, it's obvious that if they'd taken the time to speak to him properly on occasion, if you'd taken the time to speak to staff in the office and find out what the issue was with the desk, the employment relationship would probably be carrying on. So what this means for you, when I put it's good to talk, it is good to talk, but talk in a prepared manner and be ready to have those difficult conversations in a calm way. Now to actually talk about the national minimum wage.
Right, so we're going to end with talking about national minimum wage. I'm going to talk first, and then Sarah from AP Robinson is going to talk about national minimum wage as well. I'm going to go through the main principles with you. And what I have done at the end of my bit, I've set out some problems that I've had to deal with recently in respect of national minimum wage. So you'll see those set out with calculations to work through afterwards. I'm not going to take you through them. I'm just going to go through the background with you. So national minimum wage came into force in 1999, and this was to make sure people were paid a minimum wage, but that wage was also in cash as opposed to made up of various benefits. The only benefit now that can be included in the calculation for national minimum wage is an accommodation allowance. And you'll remember as well in 2016, a national living wage came into effect, and that was to top up pay for over 25s. Since 2024, that's now been merged back with the over 21. So that rate is now for 21 and over. There's no longer a separate category for them. When it first came in, it was seen as a bit of a safety net. It wasn't seen as something that everybody paid their staff. But now, because it is so high, it is you'll find quite a lot of people, and particularly on salaries as well, are now on or just above national minimum wage. So it is something you have to watch out for a bit with the salary. I've done a couple of jobs recently where I've assisted our corporate department in purchasing various businesses for clients. And when they've disclosed the salaries, I've said, I don't think the salaries and the hours, I don't think that adds up to national minimum wage. So we've seen some problems with people not realising the figures have affected the salaries as well. And I'll go through the updated figures with you. If anyone doesn't pay national minimum wage, then that's dealt with by Revenue and Customs. They've got a section, the National Minimum Wage Regulator, and they can enforce any penalties or criminal proceedings against employers that do this. Who's entitled to it? It's basically every worker or employee that you have that's under a contract of employment or under a contract of service, including agency workers. It doesn't apply to the genuinely self-employed, and it doesn't apply to non-exec directors, but does apply to directors who are employees. It doesn't apply to volunteers, but that's quite a monitored area as well. So you can't just call somebody a volunteer, they've got to be doing a specific role. And similarly with internships, it's not as common to have internships here, I think, as it is, say, somewhere like in the United States. That it's usually students or school age people that do them, but they can do them without paying national minimum wage. And very occasionally you can interview or recruit somebody for a role and do a work trial, but that's got to be particularly minimal, not an entire shift somewhere just to see if somebody's suitable or not. It can only be what is reasonably necessary to test their ability. Anything else than that, they've got to be paid at national minimum wage. Now, the rates are going up on the 1st of April, so very shortly. And these are the new rates. From someone who's 21 and over is now going to get £12.21 an hour, up from the current rate of £11.44. The 18 to 20-year-olds are going to get £10 an hour. Under 18s and apprentices are going to get £7.55 an hour. But if your apprentice is in their second year and they're 19 or over, they've got to be paid their actual national minimum wage rate, not just the apprentice rate. And I've said before, you do need to consider what this looks like now in a salary. So if you've got somebody who's a salaried worker on a 40 hours a week, the minimum salary they should be getting is £25,465.18 a year. So it's important, you're looking at the hours, looking at the salary, and from the 1st of April, checking that still is, the test is met. I've also put the salaries if it's 37.5 or 35 hours, because that's what full-time tends to be, one of those three. Now, the regulator, when assessing if somebody's paid national minimum wage, will look at your pay period, which often is monthly, sometimes weekly, sometimes 4 weekly, and then they'll look at the total remuneration received by the employee in that period divided by the number of hours worked in that period and check that they're getting national minimum wage. They do list some types of work that they carry out. There's 4 types of work that can be carried out by an employee. It tends to depend on what's in their contract, but the first is salaried hours work, where an employee is paid an annual salary by reference to a fixed amount of hours per week or annualised. That's quite important. I'll put a problem at the back in respect of that, because if somebody's a salaried hours worker, you can pay them the same amount each month, even though each month has a different number of working days because of the way our calendars work and the fact that each month's got a different number of days in it. If they're not under that category, they've got to be paid national minimum wage for exactly what hours they worked in that month. So you would have to vary it according to the number of days worked. Time work is where somebody's paid by reference to the time they work. So that's normally somebody who's paid by the hour. Output work is where a worker's paid, we call this piecework, where they're paid according to how many of a particular thing they make or process or pass, and that's all calculated on the basis of average times that it takes to make or process a particular item. And anything else falls into unmeasured work. Now, what actually counts as working time? Obviously, all the time you spend actually doing any work is working time, but there are 3 areas just to flag up with that. So travel time is working time unless it's commuting. If it's commuting from the place of work to the office or wherever it may be, that doesn't count. If somebody is training, if you've sent somebody to do some training, that is also working time that needs national minimum wage paid for. And that can include if you're providing the training away from the office or wherever it is, the time travelling to that training provider is also working time. And thirdly, if somebody is on call, this has been the subject of a lot of dispute, a lot of case law, that basically if somebody has got to be available for work and they've got to be ready for work, that is considered to be work and they're entitled to be paid national minimum wage, even though they're not working, they're just waiting. But there are two exceptions to that. One is that when they're at home waiting, so they're getting that time off, even though they are potentially waiting for a call. And the second one is when they are at the place of work, but they're asleep. That's not considered to be working time until you're actually then called out and you're doing the work. People tend to get flat rates for the night work that they do for sleeping, but it's not now necessary to pay somebody national minimum wage for that time, even though they're on the employer's premises the whole time. Now, what pay or what monies count towards national minimum wage? Basic salary counts towards it. So does bonus, commission and incentive payments based on performance, but you can't pay someone an annual bonus and then try to divide it between 12 months. When the bonus is paid, it only counts towards the month, or potentially the month prior to which it's paid. And the accommodation offset, which I've mentioned before, and I'll cover in more detail, it is something, again, I've set out an example of at the back. Payments that don't count towards national minimum wage are things, pretty much everything else, things like benefits in kind, loans or advances, pension payments, redundancy payments, premium payments for overtime or shift work, expenses, tips, gratuities, dividends, salary premiums. And you need to be aware as well, if an employee gives up some of their salary by way of salary sacrifice, that sometimes does happen for pensions or for some other for childcare provision, things like that. It's the salary after the sacrifice that you've got to use to calculate national minimum wage, not before the sacrifice. And I've also mentioned the accommodation offset. That allows an employer to provide accommodation to an employee for free. They can charge as well, but and I've done a calculation of this at the back for everyone to read, but they can then offset a daily allowance against the national minimum wage. You can add it to the salary. It's currently £9.99 a day, and that's going to go up to £10.66 a day on the 1st of April 2025. If you make deductions from a person's salary, it's the salary after the deduction is made rather than the salary before the deduction is made that has to comply with national minimum wage. And this, you can run into problems when there's things like uniform deductions made, or when somebody has to wear a particular uniform for work, because if you're requiring somebody to wear a uniform, it doesn't just count if you're deducting that from your provision of it to them and then deducting money from them. If you're requiring them to go out and buy a uniform or buy part of a uniform, then potentially that can be counted as well. So, for example, if you provide a top with a logo to an employee, but you're saying you've got to have black trousers, black skirt, you've got to, whatever type of role it is, and they've got to purchase that at their own cost, then the regulator can decide that the money that they've spent purchasing that has come off their wage for the purpose of calculating national minimum wage, even though they never bought it from the employer. So these are important things to flag up as well when calculating. Record keeping, you've got to keep your records for 6 years. That's for employees and for the Revenue and Customs Enforcement officers to check. And I've mentioned enforcement. It's a big issue not paying national minimum wage. It's a criminal matter as well as a civil matter. The regulator can issue civil penalties, it can criminally prosecute. The penalties can be 200% of the underpayment and a maximum penalty of £20,000 per underpaid worker. And criminal enforcement is usually taken in respect of persistent offenders or people that are falsifying their records. And your employees or workers can also sue for underpayment of national minimum wage. They sue for unlawful deduction of wages or breach of contract. So that's an overall picture from a legal point of view. I'm going to pass now to Sarah A.P. Robinson to go through it from an accountancy point of view.
Hello, everybody. So I'm just going to start following on from Natalie. Natalie's obviously explained quite a lot there about national minimum wage. I'll just break the topic slightly and just talk a little bit about the changes that are also coming into play for the employers' national insurance. They're also coming in on the same day, 1st of April 2025. So from the 1st of April 2025, there is an uplift in the amount that employers will pay. There is a two-tiered approach to this. So they've increased the rate that employers are going to pay national insurance. So it was at 13.8% and it's going up to 15%. They've also reduce down the tier of earnings whereby you start paying that national insurance. So previously, a member of staff would earn across the full year £9,100, and then you would start paying employers national insurance, and now you start paying it when they earn only £5,000. So the two sort of collide really, and give us a larger employers national insurance bill that we have to have as a burden. To counter that, they have the smaller employers taking it away by giving you an increased employer allowance that you can claim against your national insurance cost. So as we sit in present day today, every small employer, if your national insurance cost of your staff is £5,500 across the year or less, then all of it is covered by the allowance. They are increasing that employer allowance to £10,500. So while national insurance, the calculator will be busy working away on the increased burden, the smaller employers, a lot of it will be removed by this extra allowance that they are giving. So I can't give you exact figures, but broadly, if you've got kind of like 8, 9 staff, you're probably not going to be paying an overall larger amount to the revenue because it will be wiped away by the extra allowance. Anything upwards from that, you're going to feel it in your additional PAYE bill every month. Something else they've done is they have, so again, present day today in this current tax year, so pre the rules coming in, if you have a business whereby your total national insurance bill as an employer is £100,000 or more, then you were not eligible to claim the allowance, full stop. They're removing that. So if you're a larger employer and you've got a national insurance bill of over £100,000, you will be able to get the £10,500 wiped away from your bill come April. So they are kind of costing us more, but giving us little snippets back where they feel they should. There are some restrictions to claiming the employer allowance against your costs. If you've got a group or you've got multiple active payrolls within your business, you can only claim it once. So that's something that may or may not apply to yourselves. Also, if your business works for the public sector, so if ultimately your customer base derives its income from NHS-based funding or council-based funding to the tune of more than 50% of what you're doing in total, then you are not eligible to claim the employer allowance. An example of that would be maybe an NHS dentist, a care home that's ultimately got funded residents within that business. So that's just something to be aware of. AP Robinson & Co does have a payroll hub bureau within its umbrella. We offer our payroll services to multiple businesses to kind of watch over all of this, make sure the calculations are done correctly, and make sure that all compliance is met. So if you've got any concerns about the headaches of running payroll correctly, and also all the pension compliance, which I've not even mentioned, and there's a whole raft of other rules, then outsourcing your payroll solution can be an option to have a look at. The national minimum wage, Natalie's explained really well how it's going to actually apply and all the little caveats that come with it. I think from our point of view as accountants, we've got a lot of SMEs, so small, medium-sized enterprises. That is what we do. And it is really, really not a pretty scene. We've done lots of forecasting since the budget to try and give our clients as much foresight as possible about what this is going to look like for them. We're particularly concerned about hospitality, care and retail because they typically carry a larger bank of staff that will naturally fall into the national minimum wage compliance rules. These costs are real. They've got to be covered. Profits have got to be found, and margins we do anticipate will be squeezed. So we are supporting our clients in looking at pricing strategies to counter that. They've got to try and maintain margins where they can. And it's not just the national minimum wage guys as well. It's not just maybe the lower skilled staff that you feel, yes, they've got that mandatory rise that's got to come their way, but your next tier up and the tier after that and the tier after that, it's like, well, where do we stop? We can't just go and deal with this group of our staff. It's got to filter up. So, because if we I mean, some might not have the luxury of doing that, but if they don't, they might be looking at demotivated staff, skilled staff getting very close to potentially unskilled staff in terms of pay brackets. So these are all things that we're trying to solve, find solutions for with our clients and help where we can. Retention of staff is another thing. Obviously, as we make those decisions about pay rises, not pay rises, maybe for certain tiers, we may find staff opt to move on. They may just jump from one place to find they're only going to find the same decisions being made elsewhere, maybe slightly delayed, but ultimately this obviously leaves a small business with issues on retention and trying to maintain that, that business in its strength as it currently is. So how we can help is trying to just forecast as much as possible and really put a true angle on that as to what the business might look like in the future. So pricing's key. So pricing, the business model's got to accommodate this extra cost, and it can be quite scary. People sometimes can have quite a bit of resistance about price increases. They think, well, price is the price and we'll just not get the work, but everyone's in the same boat, and it's just going to have to be the bravest really that goes forward and tries to maintain margins where they can. Obviously in retail that's much more difficult when you are up against a lot of online trading, but yeah, we're just trying to work as closely as we can with each business on its own merit really and find solutions. Accounting software giving you good information is really important, more so than ever. It's so important now that people do actually know what those margins are so they can monitor them, and if they do feel that they are being squeezed, they can start to look at options, and those options may include reviewing the staff bank. Do I need to consolidate roles? Have I got surplus staff for the business now? And then looking at making those potentially tricky decisions. And obviously a firm like Gosschalks can help navigate that correctly and legally for you, because you've got to be lean to keep things working on that bottom line, rotas and maximising efficiencies as best you can. So yeah, that was all I really wanted to say. Just a case of sort of us doing lots of hand holding and trying to just navigate what is going to be quite a tricky time come April for our clients. Thank you, everybody.
Thank you, Sarah. That's it. That's your 1 hour seminar done, 59 minutes. Thank you for attending.